levels in relation to the project, end of quote.
Correct.
Were you able to determine the meaning of that service to be provided? And if you referred the chair to a number of video clippings you have of the negotiations, were you able to tell from those video clippings whether Tequesta was represented in the negotiations?
On the review of the videos,
Yes.
all that we know is that those were CSR personnel that were negotiating with Transnet. But you didn't see Mr. Salim Issa because Mr. Salim Issa is a popular face. So we did not see Mr. Salim Issa on the videos that we reviewed at least.
Now, staying with Annexure A, under the 6 items, the following is noted. It is hereby noted and agreed between the parties that the above services are provided as a pre-project service and will conclude on the company signing the contract for the project with the client.
Correct.
Were you able to determine what were the pre-project services?
We could not establish what that is because the same agreement vests the responsibility of compiling the bid documents with CSR. So, insofar as that lot is concerned, we are quite alive to the fact that the compilation of the bid documents and ensuring that the bid complies with the bid requirements, that was the responsibility of CSR. Now, it was quite a curious notion for us to say then, what is this service that Tequesta would have rendered to CSR to ensure that CSR secures the 359 electric locomotives?
And lastly, do you confirm that CSR bid for the full 599?
At the beginning, CSR submitted a bid for the full 599.
And yet, in the definition section of this agreement at page 5153, I note the following item being defined, Project 359. And this is defined as follows, and I quote, refers to any portion of the tender for the supply of 359 electric locomotives to Transnet SO Limited, South Africa, hereinafter referred to as the client. 359 is what was awarded to CSR.
That's correct.
And that is a result of a negotiation. No, that's pre-negotiation.
Correct.
And at the time, CSR was not aware how many they would eventually be awarded.
Correct. Because at that time, they only submitted a bid for the full 599.
Okay. So, no services then could have been capable of being rendered in respect of 359 because nobody knew that CSR would get 359.
Correct.
Is that a fair? Thank you, Chair. It's pointed out that it's tea time, 11:15.
We'll take the tea adjournment and we'll resume at 11:30. We adjourn. Yes, we may proceed.
Thank you, Chair. Mr. Sudumedi, you move on then to your slide 59. In your report, you have drawn certain inferences and conclusions from this contract, which you share with which you highlight at your slide 59. Would you like to go through that?
Correct, Chair. So after analyzing this agreement and the relationships between Mr. Sharma and Mr. Issa, we said to ourselves, surely the procurement of the 1064 was required to comply with the provisions of the Constitution 217 in particular, and the PFM relating to being competitive and fair. So we could not establish any lawful or commercial reason why would Mr. Issa, Salim Issa, interpose between Transnet and potential bidders, because the bids are supposed to be evaluated on a basis of their strength when you submit them. And it was an irresistible conclusion to reach to say, Mr. Sharma, having been the chairperson of the BADC at a time when the bids were awarded, and taking into account that he had business relationships with Mr. Issa, would have used his position to ensure that CSR is awarded this contract. So that's an inference that we are saying it was irresistible to arrive at. So it's purely an inferential reason that you say there's a reasonable inference that those are what might have transpired.
In regard to that, were you told what role he played in meetings to discuss this, or were you just basing that on his relationship with Mr. Issa? In other words, in terms of minutes, did you look at the role he played in meetings, and from which you are able to say, you know, he played a critical role in the decisions that favored CSR?
In the red chair, all I did was just we analyzed the minutes. We didn't get the transcript of the minutes, but for the minutes, as a chairperson, he was in charge of the proceedings when the management presented who the successful bidders ought to be, the split, the negotiation at Barfo with those who are shortlisted, and the ultimate award. So that's all that we could see in the minutes. But we did not necessarily interrogate the transcript to see, is there any further active role that he might have played to sway a decision away from CSR, as an example. Which is why we are saying, just analyzing
or
that.
Towards, or rather than away from, towards CSR, isn't it?
Yeah, I'm saying if ever maybe he was swaying decisions away from other bidders in favor of CSR.
Yes,
so that's what I meant. So
you didn't have access to that. You didn't see anything like that.
Correct, Chair.
Okay. So it was just the relationship he had with Mr. Issa.
Correct.
Okay.
And on that score, I don't know if you are in a position to express an opinion on the reasonableness of a bidder paying 21% of the total value of the contract received. Presumably, they do so with still profit to spare. Would you?
That was a subject of intense debate when we finalized our reports, because we quite frankly found it strange that as a business person or entity, would you be willing to forego 21% of your margin to an entity whom on the agreement, you are saying you don't even need to know what services or have they rendered. I'm just acknowledging that there is some service that they've rendered without any need for proof. So a reasonable conclusion to reach or inference is that you might have factored in this 21% when you made your offer during the negotiations. You might have found some way of factoring in this 21% that you are required to pay to Tequesta in terms of this agreement.
But that, as a matter of fact, is not something you've been able to determine?
No, it's not. That is pure, as I said, it was just an inference that we just drew in. But because we could not have something proved, this is why we didn't even include it in our report.
Okay.
Did you establish whether this entity that was going to be paid this 21%, whether it had, or what it had done, if anything, to assist CSR to get the contract? I think the agreement was saying that it wouldn't have to prove, but CSR just acknowledged that had it not been for their assistance, the CSR would not have got the contract.
At the time of us finalizing our reports, that was not done. You recall, Chair, I did say that we are in a process of engaging the OEMs. This is one of the agenda items in our discussions with CSR. And we did disclose to them when we met with them in December that there's this item that we need to really get around. So we are not yet at a stage where we have arrived at understanding the role that Tequesta would have played.
You know that earlier on I mentioned I made mention of Homix, and I thought you were the one who had given evidence. You probably have heard of Homix in terms of Transnet and so on and so on.
I have come across the name in various investigations that we've conducted.
Yes. Now, one of the issues that the witness before you testified to was that Homix entered into an agreement with Neotel, and in terms of that agreement, Homix was going to be paid some money on the basis that they had help or would help break a deadlock between Transnet and Neotel in terms of negotiations. But part of the problem was that the witness said that there was no deadlock between Transnet and Neotel that was such that it could be said that Neotel had lost the business, because the agreement was saying lost business, was referring to lost business. But also, either the agreement was reached on the day when the agreement between Neotel and Homix was reached, on the day when the agreement between Neotel and Transnet was signed, or the formal agreement between Homix and Neotel happened after the agreement between Transnet and Neotel had been signed. And also that witness gave evidence when I asked him whether, because he was an important character in the negotiation team of Transnet, I said, well, if there was a deadlock between Transnet and Neotel, and somebody was asked to help break the deadlock, surely they would speak to the negotiating team.
Correct.
Did they speak to you? You said no. Did they, as far as you know, did they speak to any member of your negotiating team? No. So the question arose, what were they going to be paid for if they never spoke to at least one of the negotiating teams, but they were going to be paid a lot of money. So you have here another entity where which is going to get a lot of money, but their agreement with CSR is that there's no need to prove what we have done. So it might well be a pattern that we see develop of how some of these things were done. I guess that I haven't, I can't remember with regard to Homex. Obviously, it's important to look at the personalities involved in Homex compared to the personalities involved in this, in Tequesta. Whether in Homex, for example, you would find Mr. Essa or some other person that features prominently in some of these transactions.
We will do that analysis, Chair.
Yeah.
Thank you.
Thank you.
You I'm still at your 59, at your concluding paragraph. Would you like to speak to that? The conclusion you have drawn regarding this transaction, this agreement.
Correct. As I said, it's just an emphasis of the point that I've already made, that there just can't be any rational basis for this agreement to be concluded in a context of an open and competitive tender process, where bids are supposed to be even on their strengths. So it means the Tequesta active efforts viewed against the relationship with Mr. Sharma would have undermined the spirit of an open and competitive bidding process.
Okay.
That was just the conclusion that we just reached on this one.
But whether or not they did,
It's something that
you
it's an
haven't determined
inference.
yet.
That was purely an inferential reason that you said. It's irresistible to draw that type of an inference.
Okay.
So it would be important to establish whether anybody in the negotiation team, in the Transnet negotiating team, knew any active efforts by Tequesta, or was aware of any such active efforts. Okay.
Okay. And that's once again something that we will pick up with those who were part of the negotiating team, Chair.
Yeah, thank you.
That brings us, according to my pack, to the end of the issues you've dealt with and you raised around the Tequesta agreement.
That's correct, Chair.
You then move on to the next transaction.
The next set of slides, Chair, speaks to the appointment or the procurement of the transaction advisors. The Chair would recall that 1064, given the magnitude of the transaction, might have required some external service providers to provide some services. So the TAs, as they are called, transaction advisors, they are the persons or the professionals that advise Transnet on, amongst others, the validation of the business case, the evaluation of these bids, how to structure the various agreements that would be required in the implementation of the project, and procurement advice, and of course legal services would have been also part of that scheme. So what we have done, so all this work is contained in 2 reports. We named them Volume 2A and 2B. For purpose of my evidence, I'll be focusing myself on volume 2A, which will be the procurement of those advisors, the contracts that Transnet concluded with those advisors, and the payments that were made. Now, volume 2B, which will be the evidence probably on Friday, will then focus on the technical analysis of the transactions that Transnet would have concluded at the instance of the advice from the transaction advisors. So I thought I must just make that delineation of the evidence and how the reports are compiled.
Understood.
Now,
Yes, please
you can then
continue.
move to slide 66. In May 2012, Transnet issued a confinement RFP to 9 entities for the appointment of transaction advisors. We know on review of the records that there were 4 responses that were received, comprised of 3 consortia. There was one led by the McKinsey Consortium, we'll talk about that, KPMG Consortium, PwC, and then there was Weber Wenzel attorneys did not form a consortium, they just submitted a bid on legal services. But for the purpose of our discussion, nothing much turns on those issues except to say that we all know that McKinsey Consortium was the successful bidder.
Yes.
And the consortium was led, this diagram indicates that McKinsey is a company incorporated. Even though the consortium was called McKinsey Consortium, it was a main bidder and a co-bidder called Letsema Consulting. And then the rest of the members were subcontractors. So, meaning the leads on this one would have been a McKinsey, co-bidder being Letsema, and Advanced Rail Technologies, NetBank, Edward Nathan, Goikanyang Incorporated, and Uto Capital, where the subcontractors, as indicated by that diagram on the right there.
Okay.
Now, we'll now deal with the findings, the MNS findings on the procurement process. The confinement RFP in volume 4, page 5637.
Yes.
I think by now you understand there are various stages of evaluation. So there was a first stage being administrative responsiveness. Amongst the various documents that were required in that stage was for the bidders to complete all the forms that were enclosed in the bid documents, but quite critically was the submission of the audited financial statements for the previous 3 years. And in that bid again, it stated, failure to comply with the provisions of stage 1 will render the bidder's proposal to be non-responsive.
Yes.
And that amounts to a disqualification. McKinsey Incorporated did not submit audited financial statements when they submitted the bid. There was no financial statement as required by the bid. But in that response of theirs, they enclosed a letter that is in volume 4, page 5336, whereat they said, and I quote, this is an extract from their letter.
Yes.
In terms of the internal governance regarding the provision of annual financial statements, McKinsey provides such statements only in terms of statutory or regulatory requirements, or when compelled to do so through any legal requirement. That's what we submit in the letter. The same letter also indicates, or it makes reference to a report of factual findings by PwC, purportedly indicating that McKinsey, because the whole idea in that letter was, we attach a PwC report that demonstrates our financial position. However, that report referred to in the letter was not even enclosed in the bid documents. Now, the requirement for financial statement is not just a miscellaneous requirement, which is just innocent or innocuous. Paragraph 13.2.6 of the Transnet Procurement Procedure Manual, which is in the volumes, it indicates that the purpose of requiring financial statements is to assess the financial stability of the bidders. That's why at a very early stage of evaluation, we need to see who are we dealing with. So it's not just one of those miscellaneous requirements that are required by the bids. So this purpose, as mandated by the PPM, could not be achieved because Transnet then could not certify itself of Mackenzie's financial stability as a result of them not providing this statement. So it was our view that Mackenzie's submission or proposal was non-responsive and should not have been entertained proceeding further in the evaluation process.
You said that is apart from the slides that's dealt with in what volume 4?
Volume?
Let's go back and start with the question of administrative responsiveness. That's where you start to direct the chair's attention to the volumes. On your slide 68, you said it's volume 4, page
5637.
Yes. And you go further in your slide.
Yes, I've got 5637 now, yes.
Correct.
Thank you, Chair. You go
Okay.
further in your slide and say that page must be read.
Read with 5647
Yes. So we keep our finger at 5637.
and
We go to
5647.
5647. Yes.
On 5637, it indicates the 8.1, step 1.
Yes, I'm sorry, I may have missed something now about, just briefly, the points you were making about test for administrative responsiveness.
Correct, yes. It's on page 5637.
Yes.
You'll see at the top of that page, again, paragraph 8,
Mhm.
evaluation methodology and criteria.
Yes.
Transnet will utilize the following methodology
Yes.
and criteria in selecting a preferred service provider, if so required. That's a standard term that they include in their RFPs.
I wonder what this "if so required" means, because I think we saw it in regard to another transaction. I mean, will there be a case where it won't be required to use them?
My own interpretation,
Yeah.
and it might be incorrect, is that Transnet doesn't have an obligation to appoint a service provider.
Yes.
I just assumed that it means it doesn't follow that at the conclusion of this process, there might be, or this might result in an appointment of a service provider. I say that based on a disclaimer that they always put in their bid documents, that they don't have an obligation of appointing anyone for this bid. That's how I've always.
That I understand, but that is in another place.
Yes.
Yeah. So this seems to suggest that we may not be required to use this methodology and this criteria in selecting a bidder.
There are two choices, Chair.
Yes.
And if I understand you, Mr. Sudumedi, Mr. Sudumedi's understanding, if I quote you correctly, is that the qualifier, if so required, relates to the selection of a preferred bidder and not to the use of the methodology.
Just repeat that.
The qualifier, if so required, relates
Yeah.
to the second portion of the statement, which is regarding the selection of a preferred bidder. So if so required, we will select a bidder. It does not relate to the first part of that statement regarding the use of methodology. As an interpretation he attaches to it, it's a question of
I'm
is
not
it
sure
sustainable?
if I understand it. Because the criteria, the methodology and the criteria they are talking about are only applicable in selecting a service provider or the preferred service provider, isn't it? That's the only time they use them. They don't use them for anything else, isn't it?
Correct, Chair.
So, if you remove the words, if so required, then what you would understand the 8 to mean is in selecting the successful bidder, this is the methodology and these are the criteria we will use.
Or, if we follow this methodology, we must take it to its logical conclusion and select a preferred bidder. Now, as I'm saying, it is reading that thing
Yeah,
in view of the disclaimers that they always put that there's no obligation to
yeah,
award. That's
Yeah.
how I made, it is even also how we made a connection that it might be
yeah.
that they don't want to be tied to finishing the process up until,
No, that I understand,
Yeah.
but that's overall. That's overall. They can follow the whole thing
and not up.
and then not appoint.
All right.
You know, so that they should put somewhere where they, in effect, they say, we can follow this process, but still not appoint. All the different stages, not necessarily 8, you know. But anyway, it might not be, it might not make any difference in regard to these transactions.
Or even perhaps to similar transactions, Chair, because we know that there is a methodology prescribed. We dealt with that yesterday in the PPMs. So it's a question of whether or not the Transnet may conduct any evaluation outside the prescribed methodology. That's a question to be debated. And secondly, then the second question that arises is whether or not in issuing an RFP, Transnet may seek to absolve itself of the imposition of the methodology in the PPM. So
Yes.
if we accept that they don't have scope to do so, then it may be argued that a proper reading, contextual reading of that sentence must be, if I am required to select a preferred service, I shall do so having followed this methodology.
Yes, maybe it might mean that.
We're trying to
But again,
lend
if
interpretation to.
you have got that qualifier somewhere,
Yes, Chair.
which says, my following this process doesn't oblige me to appoint, then you don't need this in paragraph 8. But it's okay.
But maybe when we talk to those who evaluated this tender,
Yeah, maybe they'll throw light.
maybe they will shed light
Yes.
and explain how they approached it and on
Yeah.
what basis they did.
No, that's fine.
Okay.
Correct. Now, for step 1, the test for administrative responsiveness. The test for, I'm reading this is on top of the table there. The test for administrative responsiveness will include the following. The relevant part is second bullet,
You are reading at 8.1.
8.1.
Step 1, yes.
Whether the bid has been lodged on time. Second bullet, whether all returnable documents and or schedules where applicable were completed and returned by the closing date and time. And the last bullet, whether the bid documentation has been duly signed by the respondent. The next table reads, the test for administrative responsiveness, this step 1, must be passed for the respondent's proposal to progress to step 2 for further evaluation. If we now go to page 5647, because you'll see here that on the returnables, they refers to section 4. The returnable, starting on page 5647, they list the items that must be provided by the bidders when they respond. And if you turn over leaf, at the top of the table, after SANAS, there's audited financials for previous 3 years. And there's a paragraph underneath that table to say, failure to provide all the above referenced returnable documents marked with a tick will result in a respondent's disqualification. Bidders are therefore urged to ensure that all is underlined. All these documents are returned with the proposals. And as you can see, the financials on top there have a tick. So it was mandatory for the bidders to provide at least those documents that are listed there. Now, when McKinsey submitted their proposal, the ticked audited financial statements for the previous 3 years were not enclosed.
I'm sorry, in at page 5637, oh, okay, now I think it's the second bullet point under 8.1 that must be read with 5648, 5647 and 5648.
Correct.
So one of the criteria was whether all returnable documents were completed and returned by the closing date, and 5648 makes it clear that failure to return all of them disqualifies a bidder.
Correct.
And what the returnable documents are is set out in the list at 5647 to 8. Okay, right.
And there's no discretion. There's no discretion that has been afforded to any person.
Sorry.
There's no discretion.
Yes.
As to whether you'll be disqualified or not. Penalty indicates that you are going to get disqualified.
Yeah. And then you were dealing with, you were starting to move on to the point of showing that somebody didn't return all the documents.
Correct. On slide 69, we are referencing the letter from McKinsey contained in volume 4, page 5336. 5336.
Okay.
This letter.
2 seconds, Mr. Sutumedi. Okay.
Yes.
It's from McKinsey. It is part of the bid documents. The heading there is Policy on Provision of Annual Financial Statements. McKinsey Incorporated, in the state of Delaware, United States of America, South African branch, is a privately held entity. In terms of the internal governance regarding the provision of annual financial statements, McKinsey provides such statements only in terms of statutory or regulatory requirements, or when compelled to do so through any legal requirement. In order to provide details of the financial bona fides of McKinsey, An original statement from the auditors of the entity is provided. Please refer to the original report of factual findings as prepared by PricewaterhouseCoopers, covering the financial period as required. In the event that McKinsey is successful in its submission, and it remains a requirement to view the annual financial statements, the annual financial statements can be viewed through an on-site inspection. That was a letter that was enclosed in their bid document.
So the bid document required financial statements for 3 years, audited financial statements for 3 years. And McKinsey found it fit to provide financial bona fides, whatever that may mean, instead.
Correct. Which, for the record, when you reviewed their bid, that report that purports to indicate their financial bona fides was not enclosed in that bid.
But the starting point is that they failed to comply with one of the bid requirements to furnish audited financial statements for the periods that was indicated.
Correct.
And in terms of what you have referred us to in this bundle, Exhibit Volume 4,
Yes, Chair.
they should have been disqualified. Is
That's
that right?
correct, Chair.
Is that right?
As per the requirements in the RFP.
Yes. Okay, thank you.
And we know they were not disqualified.
To cut it on, the McKinsey was eventually the successful bidder on this transaction.
Were you able to establish through your investigation the basis on whichever body decided this tender or this award, why the requirements of the RFP were not upheld?
That is not apparent in the records that we reviewed. We assume they just took McKinsey's word for it as contained in this specific letter.
And in the considering the purpose of the financial statements, as espoused in paragraph 13.2.6 of the PPM, as you state in your slide 69, such documentation is necessary to enable Transnet to test the financial stability of a bidder.
Correct.
We know that we don't have them now. So are we to accept that McKinsey was awarded, notwithstanding that Transnet could not test its financial stability?
Correct, yeah.
Okay.
There would have been a team or body that would have determined whether McKinsey should go beyond stage 1. What was that body or team?
Ordinarily, this would have been a cross-functional evaluating team that would have had to evaluate this part of the bid.
Yes.
Again, ordinarily, there would have been what they call the Transnet internal audit that would review such a process. So those structures at least would have been required to check if the evaluation of this bid was in line with the process.
With the requirements of the RFP.
Correct. So that, I mean, the whole governance surely would have been required to test that this bid complied with the requirements of the RFP.
Would that team, as you understand the position, would that team have been a standard team that does this kind of job for stage 1 in regard to all tenders, or does its composition change depending on the nature of the tender or transaction involved? Because the witness before you did give evidence in regard to Neotel and CSR, and there was a team. I think they were also called cross-functional, whatever team.
Evaluation team.
Yeah, and if I recall correctly, in regard to the transaction that the witness concerned was testifying about, they changed, or they recommended the changing of one of the evaluation criteria in that case.
Yes.
So it would appear that in regard to this transaction that you are testifying about, to the extent that there may have been such a cross-functional evaluation team involved in evaluating whether McKinsey's bid should go beyond stage one, it would appear that they either did not pick up that McKinsey did not comply with this requirement of financial statement, or maybe they did pick that up but decided that there should be condonation, or that this was not such an important requirement, or maybe they also recommended that this requirement should be waived. So it would be important to establish whether each time we are dealing with the same people who form the team, or is it different people, and whether there are certain personalities that appear in each such team, if those teams are different. But you say you don't know the composition of such teams or such team.
What we can confirm, Chair, is that the CFET would be customized in accordance with the bid at hand.
Yes.
So there's no generic CFET.
Yeah. So it is put together each time there is a transaction where they would need to do this kind of evaluation.
Yes, because you need to look at the expertise required to assess the capabilities of the bidders that have submitted. As an example, a CFET to evaluate the 24 locomotives, as an example, won't be the same persons that will be evaluating a transaction like this.
Yeah, yeah. But your team, you didn't seek to establish who were the people who made up that team in this particular case.
Such record will be in our records in the office, Chair.
Yes.
Even though that did not necessarily get reflected in the report, because for us it was more to say just an analysis of the documents at hand.
Yes.
The members, whoever they are, that's not even an issue.
Yes.
Those persons failed to evaluate this bid in accordance with what was required out of them.
Yes.
But to an extent that maybe that will be required, we can provide information on who would have been the members of the CFET for this specific transaction.
Yeah, no, that's important. And in regard to the other transaction involving Neotel Masilo,
yes, Chair.
I think we must also check that, just see whether there may be certain personalities that are common to both teams.
Indeed, we will, Chair.
Thank you.
And perhaps on this score, Mr. Sidumede, yesterday we dealt with a number of cross-functional evaluation team reports in respect of different transactions. Insofar as this transaction is concerned, are you aware of one such report? Because if memory serves me well, normally at the end of that report, a couple of people sign the report, and that might begin to answer the question that the Chair poses as to the identities of the members of that team?
Yes, they would. For each and every phase, you'll recall even on other transactions, somebody would have to sign off to say, this is the evaluation that we have done, and these are the persons that must be appointed. So we will check in our records who are the persons that would have signed off on this specific phase.
Now, my question is, do you have in your record, as it currently stands, copies of the CFET reports regarding this transaction from your recollection? Are they part of the record?
From my recollection, I don't remember that being part of our annexures.
Okay.
Because like I was saying, in the main, we're looking at the documents and what transpired. We definitely did not or came up with a document that seemed to recommend any change or waiver of the evaluation criteria in this specific instance.
Okay, then as we have indicated to the chair, you will make a search of your records and see what reports you can unearth regarding the evaluation of this tender, and then we will submit them to the commission.
Correct.
It would be strange if McKinsey's omission of the audited financial statements was not picked up by that team, because its sole function is to check whether those requirements are met. So I'm very interested in seeing what the explanation is for McKinsey to be allowed to go to stage 2. Did they check all these requirements? Because it's like a list that you must tick. Yes, we have seen this. Yes, we have seen this. This is not there. Yes. You know, and then if it is not there, why are they not disqualified?
Indeed, Chair. We then...
So in particular, it may be that the chairperson of that committee, if it is established that it did go through such a committee, that committee may have to be called to explain. Yeah.
Yes, Chair. We've made a note of that, Chair, and we shall revert. We then move on to page 70, if my order is still right, of your slides.
It is correct. After the evaluation of those bids, on 26 July 2012.
I'm sorry, Mr. Sedumaji. At a certain stage, relevant people saw your report. What answer did you, or comments did you get with regard to the fact that in terms of the RFP requirements, any bidder who did not supply all the documents should not have gone beyond stage 1, but McKinsey proceeded beyond stage 1 despite the fact that they didn't supply financial statements? Were you given any answers by all relevant authorities that were still within Transnet?
This report was submitted in March this year. It was made available to Transnet. So the same modus operandi where they will circulate that to the executives. The report was also availed, or the findings thereof, to McKinsey, because we have been in engagements with McKinsey as well on some of these issues. They confirm that indeed, so there's no dispute about whether they did not provide. They did confirm that indeed they did not provide the financials, and this letter is a standard letter that they normally use when they respond to bids or requests for proposals, and it has not been an issue. So that's the furthest that we could.
They said there was no, this was never made an issue with them by Transnet.
Correct.
Yes. It's just that it's quite a serious thing, because you know, Transnet could end up giving a big contract to an entity that really doesn't have the financial strength and other abilities to carry it out. Yeah, okay, all right.
Thank you, Chair. You move on then to the co-bidder
Correct.
at your slide 17.
Right. So on 26 July, the Transnet Acquisition Council awarded this contract then to McKinsey.
Mackenzie Consortium.
McKinsey Consortium, my apologies. Now, on 22 August 2012, there's a memorandum compiled by Mr. Arnot Singh to the group chief executive, who at a stage was Mr. Brian Molefe. In one of the issues raised in that memorandum is that there's a conflict of interest between Letsema. Letsema was one of the consortium members of the McKinsey Consortium. He says seems to be a conflict of interest between Letsema and Barloworld. So McKinsey will be required to replace Letsema with another entity of equal standing with Letsema or better. That's the phrase that they used in the memorandum. There's this conflict. So that's all that we could see. But the memorandum did not necessarily expand on the nature and extent of this conflict between Letsema and Barloworld.
Were you able to establish in the course of your investigations, I appreciate that you haven't had opportunity to interview Mr. Brian Molefe or Mr. Arnot Singh, but from other employees within Transnet, were you able to determine the nature of the supposed conflict between Letsema and Barloworld that necessitated Letsema to fall out of this consortium?
Various inquiries that we made with some of the officials we interviewed, we could not get a clear answer or explanation as to what is the nature of the conflict. I think we have just accepted as a fait accompli that there seems to have been some conflict of some sort, which necessitated Transnet advising McKinsey Consortium that it will have to replace Letsema with a bidder or entity of equal standing or better.
And the chair can accept that you have not interviewed Letsema or any of its directors?
We have not interviewed Letsema.
Okay. Yes, you may proceed.
No Barloworld.
No Barloworld, yes.
Now, on this slide.
Well, we will need to get to know exactly whether there was a genuine conflict of interest there and how it was handled. The investigators can also do that.
Yes, sir.
Of the commission to
Yes, sir.
to talk to those people to try and establish what kind of conflict of interest was that.
Indeed, Chair.
Yeah.
Yes, sir,
Okay.
we will. Yes, sir. Mr. Sidumedi, may proceed.
Now, in dealing with this whole replacement of Letsema, we've first analyzed the bid submissions of McKinsey to establish what role would Letsema play within the consortium. You know, its standing is a minor role player or a key role player. These slides, the next two slides, indicate the roles that the consortium itself assigned to various members of the consortium. So on the left, those are the issues that would have been put in the RFP to say these are the requirements that Transnet have, or the strengths or the skills of the members. And the chair will note that Letsema played, or at least when you look at the RFP submission or the bid submission, Letsema played quite a key role compared to, I mean, just on slide 71, NetBank, there's only one role for NetBank, there being the ability in project deal structuring. Whereas Letsema and McKinsey played significant role on various items. The same principle applies on the next slide. So that's a consistent pattern. In actual fact, if you don't necessarily referring to a document, the percentage that Letsema had was quite a significant one. The highest would have been McKinsey, if my memory serves me, was 88 or 85, with Letsema being on 20, and the rest of the subcontractors had a smaller portion of the cake. So Letsema was a key partner in this consortium. In actual fact, you'll recall that the bid said it was Letsema is a co-bidder. That's the way that was used in the proposal.
And I don't know if you went to the actual report. Mr. Singh's report you referred to at volume 4, page 5528. This you have in your page 17. At 5530, actually sets out in percentage terms the work split amongst the various consortium members.
Correct. That will be
Volume 4, 5530, at item
Yes.
17.
That's where I saw the split. Page 5530,
Yes.
the heading is financial implications. The estimated value for locomotive advisory services required is 50 million. The percentage split of the work is anticipated to be as follows: McKinsey, 35%, procurement partner, in brackets, Letsema, replaced due to conflicts, Pillai is 20%. So the stake for Letsema was 20%. And then the UTO and NetBank 10%. Weber Wenzel, will recall, Chair, was not part of the consortium per se, because they submitted their bid for individually. They had 20%, and advanced rail technologies was 15%. So that demonstrates the key role that Letsema played in the configuration of the consortium.
You might or might not be able to answer this question. When a tender has been awarded to a consortium or joint venture, and there is a problem which results in the consortium or joint venture not being able to continue with the contract as they are, or as they were when they were appointed, are they free to just change partners and continue without the employer having an opportunity to see the joint venture that will continue, or to look for another one? Or is there something that you wouldn't know?
That's exactly what is contained in our report, Chair. The view that we hold on that matter. Because we know that post this memorandum, maybe let's just talk about what happened thereafter, so as to properly answer the question that the chair is asking. On 6 December 2012, Transnet then issues or concludes what is called a letter of intent. And in that LOI, letter of intent, it described the parties as McKinsey being the supplier, and they list as well as other members of the consortium, namely Regiments Capital, Advanced Rail Technologies, NetBank, and Untitled Chapter. Now, from this letter, you could see now that Regiments is the entity that would have replaced let's see. So the view that you held in the report is that, and this, remember, all this happens pre-award. It's not like the reconfiguration happens after the fact. This at the stage, we pick up this conflict before we award this bid. And it says, let's say, Mackenzie must find a replacement that is of the same value. The view to hell was that it cannot be up to Mackenzie to make a determination of who is of equal standing. They got the points that they got, being the preferred bidder, on the strength of the submissions that they've made, and that informed by the expertise that various members of the consortium would have brought to the table. So it is that would have enabled them to outscore the other bidders. So it then goes without saying that any person that substitutes, let's say, or any member for that matter, should be put through at least the same process, albeit probably at a lesser extent, to determine if with this entity is the McKinsey Consortium still meeting the requirement of being the preferred supplier. So from the records that we had, we could not seem to find anything that suggests there was some re-evaluation of some sort to test the strength of Regiments. In actual fact, the letter of intent, it says Mackenzie has agreed to partner with Regiments.
Suggesting maybe inadvertently that the new entity was suggested to Mackenzie, and Mackenzie agreed. You need not say anything. Okay. Yes.
Yes, Mr. Sidumedi.
I'm just saying the language suggests that it didn't come from Mackenzie.
At least the reading of that.
Yeah, the language.
It's a curious way of putting it in the LOI, but it is what it is.
Yes.
You may proceed, Mr. Sidumedi. So now we know at this juncture the LOI already recognizes Regiment's capital as a replacement for Letsema.
Correct.
And the point you make at your 74 is that Regiments was not evaluated.
Yep.
So there was just a direct replacement without assessing the impact of the loss of Letsema to the consortium relative to the other consortia and whether they still occupied the first position.
It's correct. So that process, we reckon, it was irregular as well. Now we now know that we are now at a stage where there's an LOI.
Yes.
We thought it appropriate that we need to just highlight the key terms of this LOI because it becomes important as we go through the various phases of this process.
We are now at your 76.
That's slide 76.
Yes.
So one, the LOI, even if the word says letter of intent, but for all intents and purposes, it regulates the relationship between Transnet and McKinsey Consortium. pending the conclusion of a master service agreement. So it was contemplated that this LOI will at some point be replaced by a proper master service agreement, as they called it in the document. And the LOI itself would be valid for 90 days, or when the MSA was finalized, whichever comes first. If the MSA concluded prior to the expiration of 90 days, then obviously then it will then replace the LOI. It also specifies that the advisory services that will be performed under the MSA will be for 9 months, commencing 15 January 2013 to 15 October 2013. Any deliverables that will be completed, that are not completed by 15 October, which being the expiration of the 90-day period,
Yes.
would continue at no cost to Transnet.
If I may, it might assist perhaps the chair, if we find the actual MOI. I do appreciate at your 76, that is a summary of the MOI. And on your previous slide, you had indicated that it is volume 7, 6570. And it might help to have it close at hand, because there are a few questions I would like to get your view on, or answers to from you.
Okay.
Volume 7, 6570.
You say volume 7.
7, Chair.
And what's the page?
6570, Chair.
Thank you.
And I'm looking at page 6571 in particular, under conditions precedent. You state in your slide that at item 3, bullet point 3, the transaction advisory services were to be performed under the MSA for 9 months. I just want to check this with you, whether that is not meant to be under the LOI or MSA, as the case may be, and I say so with reference to paragraph 101 in its wording.
1.1.
Yes.
Yes, 1.1.
Okay. So to the extent that your slide may suggest that the 9 months starts to compute from when the MSA is signed, that's not what you intend to communicate?
Yes. The point was just the relationship between Transnet and McKinsey would be for a 9-month period. But you'll recall that the LOI itself is supposed to
Yes.
endure for 90 days.
Okay. I'm clarified. Thank you. May we continue?
Okay. And the point that I made earlier on, that McKinsey agrees to contract with Regiments as their SD partner, SD being supply development partner, and the LOI as well puts up the contract value to be 35.2 million,
Yes.
and the breakdown of how that figure should be split in terms of the various services is on slide 77.
Yes.
That becomes key as we move forward, because you'll know that there's a budget item for each of the services that the consortium will provide to Transnet. Just want to flag that, because we'll come back to that issue, I think, some 6 slides down the line. Now, on 4 March 2013,
Yes.
because that was just before the 90-day period would expire, the parties then conclude what they called a first addendum to the LOI to extend the duration of the LOI from 6 March to 15 October 2013.
Okay.
Then again, and that is contained in volume 7, page 6, nothing much turns on that. On 14 October, the parties then, again, because that is now before the date of 15 October, they conclude a second addendum to the LOI to extend the duration of this one from 15 October to 13 November 2013.
And that now exceeds the term period of the engagement.
That exceeds the 9-month period that we referred to earlier.
Okay.
Because that, you'll recall, would have actually expired on 15 October
Yes.
2013.
Yes.
Be that as it may, 13 November comes and goes. By the time 13 November comes, there is no further extension to this LOI. Meaning, strictly speaking, by this date, there is no agreement between the parties. And if I confirm that at least by this date, McKinsey was paid a total amount. There were 2 invoices that they submitted. It was 11,003,000 rand to round it off. So beyond 1 October, there was no privity of contract between Transnet and McKinsey.
Beyond 1 December?
From 1 December 2013. Remember, 13 November 2013, that's when the period of the second addendum comes to an end. However, on slide 79, we see an agreement signed by Mr. Arnot Singh. The parties to that agreement is Transnet and Regiments.
Yes.
And the key issues of that agreement is that it provides for Regiments to provide some of the transaction advisory services which were part of the LOI. We know from our review of documents that at this time, 20 January 2014, Nedbank had pulled out of the consortium, and this was, if I was testified as well to by Mr. Khaled, because Nedbank was saying they were going to, or not Mr. Khaled, it was the GCE, Mr. Mohammedi, that Nedbank had wanted to provide downstream services when the swaps and those things were concluded. So it's at this point when now this agreement to appoint Regiments to provide that service. And the duration of this agreement was supposed to be for 12 months, commencing 24 January 2014. And the cost of the services was to be 15 million rand for this ring-fenced service, plus 10% proved expenses.
So now let's understand. We know that there's an LOI
Yeah.
for a 9-month contract for provision of certain services. A first addendum is issued to extend the LOI. That's followed by a second addendum to extend the period of contract.
Correct.
And no further addenda are issued thereafter. The effect of that is by the 1st of December, that contractual relationship has ended.
Correct.
2 months later, on the 23rd of January 2014, Mr. Singh signs an agreement with Regiments. What was the purpose, main purpose of this agreement? And how does it interrelate with the LOI?
at least the reading of this agreement,
Yes.
it makes reference to the services that are listed on the LOI.
Okay.
But we could not pick up, and this will see when we look at the notes that, because on its own, if it's viewed on its own, there ought not to be any relationship between this document and the LOI, because the LOI had lapsed in any event.
Yes.
But strange enough, the services that are referred to in this agreement are the services that are contained in the letter of intent.
Okay.
Some of them, at least. That's the only connection that one could make between this document and the LOI.
For now, can we accept, based on the parties to the LOI, that Regiments was not a direct party to that contract?
Correct, which is why I'm saying that's the only connection between, because Regiment was not a party to the LOI with
Okay.
Transnet. The only link is that this document seems to make reference to some service that is in the LOI.
All right. Thank you. We proceed.
Then, when Mr. Singh signs this document, he makes the following notes that appear on page 6590
Yes.
of the bundle. He says
That is Exhibit 4, 6590.
65, okay, that document, Chair, Exhibit 4 starts on page 6587. These are the agreement that we've been dealing with.
Volume 7.
Volume
page-
7, page 6587.
That's where the document starts?
That's where it starts.
Oh, it's Volume 7.
Yes, Chair.
I think I'm looking at Volume 7, but we've been dealing with Volume 4 for such a long time.
That somehow we got stuck in volume
Yeah.
4.
So the page is 6587.
87. That's where the document starts, and that's what Mr. Sidumedi's slide suggested, slide 79. And you wanted to refer us to a particular page of
Correct.
this document,
Which
yes?
appears, that's page 6590.
6590.
You'll see there where Mr. Singh signs. He says, subject to items listed below,
Yes.
and that's what has been paraphrased in the slide. But in a sense, he says, the contract for the supply of these services is with McKinsey, and Regiment Capital is contracted to them,
To Mackenzie.
to McKinsey.
Yes.
Furthermore, because in this document it envisaged a performance fee, so he says
Payable to?
to regiments.
Okay.
So he says regiment is not entitled to a performance fee,
Yes.
so that clause must be removed. He further says the payments in terms of this agreement will be made to McKinsey, so which is why I was making that link to the LOI. And the costs and payment against the scope may not be above 9 million rand without specific approval from Transnet. So that's what Mr. Singh notes on this agreement. The conclusion that we have reached is that this agreement is irregular in that there's no procurement event that preceded this agreement. If you look at the parties, it's Regiments and Transnet. And Singh would not have had the authority to bind or appoint transaction advisors on behalf of Transnet, because this was not falling within this delegated authority, especially looking at the amount that you're talking about. 9 million.
Yes.
So that is insofar as it relates to this agreement.
Now, I'm at page 6590, which is the signature page of that contract. And I note the following, that Mr. Singh signed this contract on the 14th of January, no, on the 23rd of January 2014.
Yep.
Oh, and then Mr. Niven Pillai, on behalf of Regiments, had signed it on the 20th January 2014.
Correct.
So Mr. Pillai signs first and Mr. Arnot Singh signs later. When Mr. Pillai signed the contract, the conditions set out there by Mr. Singh were not there.
Correct.
So when Mr. Singh accepts the contract on its terms, he then inserts the conditions.
Correct.
Do we have a record of whether or not Regiments agreed to, because effectively those conditions would amend the terms of the contract?
This will amount to a counter offer of some sort.
Now, do we know what the attitude was of Regiments was regarding this counter offer or suggested amendments to the contract? Were they acceptable or not?
We don't have any record at
Yes.
stage of the fate of this agreement as to whether Mr. Pillai, on behalf of Regiments, did accept the counter proposal coming from Transnet.
Okay.
Which is why we had to assess this agreement based on what we see on this document.
Thank you. You may proceed.
So the point being made is that, at least looking at the notes of Mr. Singh, he seems to acknowledge that Regiment has no contractual relationship with Transnet, which is why he says these sales are with McKinsey and Regiment is their subcontractor, and as well the payments, when will be made to McKinsey, not Regiments.
Now, based on what you just said, what Mr. Singh notes on the document is an acknowledgement that Transnet has a contractual relationship with McKinsey.
At least that's what
he suggests.
That's what he suggests.
Whether or not is factually correct in that regard,
it's another issue.
It's another
altogether.
issue.
Correct.
He appreciates, though, that this particular contract that requires his signature is with Regiments for services being provided by McKinsey.
Correct.
And he proceeds to sign it.
He proceeds to sign the agreement.
So what is the effect of the condition that the services you seek to provide to me are already being provided by McKinsey? Have you applied your minds to that? Do you have an opinion?
We just found this to be a very, very strange document, Chair. Because like you said earlier on, in as much as it makes reference to the LOI, the person deciding here is not even a party to the LOI. You tell Regiments that, okay, I agree to this sales is contained in the LOI. When I pay, I'll pay Regiments, McKinsey, but McKinsey is not even part. It's not like this is a tripartite of some sort. McKinsey is not even part of this document, which is why our own opinion was that this document is just an irregular document, more so because we cannot pick up any procurement event that would have culminated in the conclusion of this agreement.
But also, why the need to include in an agreement with Regiments services that are already provided for in an agreement, in the agreement with McKinsey?
Correct.
What is the need? And two, there doesn't appear to have been any compliance with any procurement requirements and procedures. Here it looks like Regiments was just identified. Is that right?
That's what it seems like
That's
when
how
you.
it
That's the only
seems.
conclusion that one can reach when we
Yes.
get this agreement, because it
Yes.
just sprouts
Yeah,
from nowhere without any procurement event that. Okay.
yes. But you implied in your evidence that in terms of that agreement, there may have been other services that Regiments was required to provide which were not covered by the agreement between Transnet and McKinsey.
Correct, Chair, because when we analyzed the deliverables in terms of this document against the deliverables that were contained in the LOI, there seemed to have been some additional items, but even though in the main, you could say that the scope relates to the financial advisory services that were conducted or supposed to be conducted by Nedbank in the main LOI. That is our observation when you just looked at but in the main it was those services that were contained in the LOI.
Sorry, looking at the agreement with Mackenzie, recognizing the seeming overlap between that and the LOI, are you saying the Regiments agreement purported to extend the scope of the LOI insofar as the services to be rendered by Nedbank were concerned, or is it replicating the same services that are contemplated in the LOI? I think that was the chair's question. Does this contract award more services than were originally covered under the LOI, or is it the same services, albeit not all services contemplated in the LOI? Which is broader of the two, as far as the services are concerned?
This agreement, Chair, expands or provides for more services,
Okay.
which is why as well you see them even allocating an amount for this, to say this service will be 15 million rands, but if you exceed 9 million rands, you must seek Transnet's approval.
Okay. Now, have you found any documentation that would indicate whether or not, firstly, Mackenzie was aware of this agreement, considering that Regiments is a co-partner in its consortium on practically the same services, and expressing Mackenzie's view on this agreement?
We have not as yet engaged Mackenzie on this agreement, but it's one of the issues that, as part of work, there are various issues that we are engaging Mackenzie on. So this is going to be one of the issues that we'll be raising with Mackenzie. But to date, we have not picked up any document that suggests that Mackenzie was made aware of this agreement.
Thank you. Chair, my clock seems to indicate it's lunchtime. I don't know if it's the opportune time for the chair to take a lunch break. I was hoping to finish by lunchtime, but judging by what is left, I will finish both witnesses today, still by 5 o'clock. Yes, Chair.
I think when we come back, I would like to know whether, through your investigation, you established that there were services that Regiments actually did provide under this agreement that they had separately from Mackenzie with Transnet.
Chair, that will be covered with the subsequent slides. That part is
Yes.
still coming.
Okay. We'll take the lunch adjournment now and resume at 2. We
Thank you,
adjourn.
Chair.